Welcome to the Arbitration Conversation. So in this webisode, we have the pleasure to talk with a leading arbitrator, mediator, and litigator in Chicago who's done work with the AAA, with ICDR, with FINRA, what else? I don't know, he'll have to fill us all in. He's Nick Gowen, and I really am super thankful taking the time today. Thank you so much, Nick.
Thank you very much, Amy. I appreciate you having me on your show.
Well, I kind of botched, so tell us a little bit about yourself and your background of how you sort of got into arbitration at all.
You know, I've been arbitrating matters as an advocate for most of my career now. So I've been practicing about 17 years. So I've been actively in arbitrations for about 12 years. So I've arbitrated matters in the AAA, the ICDR, FINRA, the Center for Conflict Resolution, which is called the CPR, private arbitrations, as well as local court-required arbitrations here in the Circuit Court of Cook County.
Well, and I understand it's mainly commercial type disputes. Is there any certain type of commercial dispute that you have spend your most time working with?
I would say most of my time is spent on complex commercial disputes, UCC actions. That's typically the type of contract dispute that I've been working with, but I've also have experience with securities litigation in FINRA, as well as any number of construction litigation matters in other arbitration forums.
Well, so before we kind of started recording, we were talking a little bit just about how arbitration has just become so common, and that a lot of times, law students don't think about that, right? They think about litigation and going to court. So for you, maybe you want to share a little bit about your experience. I mean, how did you, like your first arbitration, being a young associate, sort of how did that come about?
You know, my first arbitration was back in 2009. It was a mid-level associate, I think, senior associate maybe, and it was in FINRA. So it was during the financial collapse, and we had a number of high-profile, high-cost arbitrations on behalf of individual clients against large banks. So, Bank of America, Credit Suisse, and all the national and global banks for any variety of, I would say, securities actions. So that's how I started in arbitrations. And I realized at that time, it's like, there's a lot going on here that is outside of the realm of litigation. And if you don't understand it, it becomes a trap for the weary. It becomes confusing also.
What are some of the main differences, arbitration versus litigation, in your view?
In my view, the main difference is because it is a creature of contract, everything is based upon what the parties agreed upon at the outset of the agreement. And it's not based necessarily on the rules of civil procedure or the rules of evidence. So there's often very little discovery, if there's any. And there's also more of an agreement as to what the parties will agree to in discovery, what they will produce. And I find that people who are unfamiliar with arbitrating claims, they tend to believe that they're in litigation and that they can have broad scale discovery. And my approach, I'm telling my secrets now to the world, is to object to any large scale discovery. Because when you think about arbitration as a device, not here just in the US, but even in the Europe and other civil law systems, people focus on arbitration to eliminate the cost of litigation. So as a result, oftentimes there's no discovery, and that's my angle. So that's my secret. I try to push and say, look, this is what the parties agree to. Let's get to hearing within 6 months. And if we can't get to hearing within 6 months, then, at least try to get it within 12. I'm going to object to any level of deposition. I'm going to object to anything but a minimum level of document production, and we're just going to go all out.
Well, and the thing is, I mean, I remember also as a young associate when I first had my first arbitration, and I realized I liked it better than litigation just because there was less discovery and you didn't have the same sort of interrogatories that go on forever and ever and ever, and it can be more efficient that way, and sort of get down to the disputes and then get to some answers.
Right.
But I'm wondering, that kind of gets me to a question about one of the criticisms, right? So one of the things, the criticism is that, well, arbitrators are just going to split the baby. They're just going to, go down the middle. I'm not going to really get a clear answer on my claim because the arbitrator is really just going to give a compromise award. What is your answer to that? What do you see?
I would say before I became an arbitrator and before I had a lot of experience in arbitration, I believed the same thing. And I think, one, it's a common, I'm going to say misconception because I don't believe it's true. And according to the American Arbitration Association and the statistics that they release annually, it's also untrue. So it's not just with my own perception. And what I have found out in my experience, and I've arbitrated cases in a number of different venue across the country, is that typically arbitrators are thoughtful, intelligent people, and they're looking to make the right decision. And I think the problem that most people view, most lawyers view it as, is that as long as someone is being paid to do the job of an arbitrator, they're going to ensure that they're not going to upset anyone. And I don't think that's true. I think what's actually happening is arbitrators put a lot of time and effort into determining which side is right and which side is wrong. And as a result, it's not really a compromise view. It's closer to what the appropriate view is. And when you think about commercial litigation, there are rarely 100%, there are rarely parties who are 100% right or 0% right. So as a result, it's a compromise anyway. It's just a matter of how you get there.
Well, and I think the other point about arbitrators is that they're experts in the area. And so often they'll want to do what they see as the correct decision based on the evidence and the law, because that's their expertise and it's what they're paid to do. So I would think that sort of means they are less likely to do a compromise. And as you say, that is the statistics that have come out of the AAA, and other statistics have been similarly suggesting that they're not necessarily compromised decisions.
Right. And I think it is a misconception. And I think because people have that view, it's like, well, no, you're being paid by the parties. So of course you're not going to upset the parties. And I don't necessarily agree with that.
Right. No, I agree with you. I guess, though, the one thing, of course, we've been talking about the pros, but what about the cons? I mean, what are sort of the limitations of arbitration, especially as compared with litigation?
Well, I think there are a number of cons. So I believe in playing this objectively. I'm going to play it down the middle. And I think the biggest negative is once an arbitration starts, it's unlikely to stop until you've gotten a decision in the hearing. There's almost no chance for an arbitration to be dismissed at the pleading stage, and it's unlikely for an arbitration to be dismissed at the summary judgment phase, although I've been successful in that arena, but it was on procedural matters and not a substantive matter. In most situations, an arbitrator is going to determine that why make a decision at summary judgment when I can just take this to hearing and determine what all the evidence is and then make my decision after that. And frankly, a lot of judges, at least in state courts, think the same thing because they're less likely to be overturned after viewing the evidence versus making a decision based purely on the law.
Yeah, I would see that as definitely as a limitation. Also, on the flip side, we talked earlier about the expediency of discovery in litigation, but can't that be sort of a double-edged sword?
It can be. One of the problems that I think that does happen in arbitration is if the parties view it purely as an economic advantage, that they can go into arbitration to save money. And that's not necessarily true if the parties aren't mindful of the cost. which means they understand that when they go into arbitration, that it's intended to be limited discovery. It's intended to be limited document productions, limited if any depositions, and you're intended to get to trial quickly. And I think one of the reasons that arbitration does increase cost is because you have advocates who are treating it as if this is federal court litigation, and it's not. It's not intended to be that.
Right. Well, then sometimes you actually, I mean, litigation may be better for you in a situation where you actually need to get certain discovery that you're afraid you aren't going to be able to get in arbitration.
Absolutely.
I would imagine that also.
Absolutely. I mean, it's also very difficult to get third-party discovery, particularly third-party discovery outside of a jurisdiction in arbitration. So if you think you're going to need third-party witnesses who are outside of your jurisdiction, then arbitration may not be the best forum for you. Now, that said, if you don't care about that and you actually think that the other side may need third-party witnesses, then it may make more sense to be in arbitration.
Right. Well, and then of course there's the whole question of when it's sort of, you often don't have a choice because it was a pre-dispute arbitration clause. So you didn't know at the time that you might need third-party discovery. So
Correct. Correct.
Well, this is any other main sort of tips, tricks, or things to think about when you think about arbitration versus litigation?
Sure. I think one of the main processes is before you file your arbitration demand, use that as an opportunity to resolve a dispute early on. You know, don't be afraid of doing that, because you are, depending on the value of the case, you're telling the other side, say, look, once we start this, everybody's going to be spending money because it's not going to stop. So depending on the value of the case, you may be able to bring the parties to some type of a resolution early on. I mean, I have 2 arbitrations going right now in the AAA where I'm the claimant in both. And one of the arguments that we've made to the other side is, look, this is our demand. You see it. We're going to file. We're not going to have any further negotiations when this is done because we've already now spent the money to file it. So once we file, it's over. Now, the problem, I should say the flip side of the coin, is unlike litigation, is once you do file it, you're there. So if you're not ready to move forward, it could be troubling. It could be problematic. So fully evaluate that before you go forward.
That's really good from a strategic standpoint. Absolutely. Yeah, because once you're in, you're in. So you have to kind of think about that. I mean, sometimes I would think preliminary hearings can help to facilitate settlement before you actually start the process. But yeah, once you get past the preliminary hearing, then you're really in it to win it.
Right. Exactly.
Yeah. Any other final thoughts?
I think that my final thought would be to understand that the goal of an advocate should be not just to win, but to get the best result for your client. And I think oftentimes trial attorneys, litigators, they're so focused on the win that they lose aspect of what they need to do to actually accomplish the best outcome for their client. And that could be to beat your chest before filing your arbitration demand, or it could be learning that you need to stick your tail between your legs and say, all right, we're going to set this aside, we're going to move forward, or consider what the real value of the case is and decide whether you need to proceed or if you need to push a settlement.
Yeah. And I love that. I love the focus on problem solving and trying to think about, getting the best result for your client and really trying to solve whatever that problem is in the best way possible, whatever that is.
Right.
I really appreciate that greatly. In fact, I teach a class called Lawyering and Problem Solving because that's what being a lawyer really is. It's trying to solve problems and get the best result you can for your client. So
that's all we can hope for.
That's all we can. Exactly. Well, listen, Nick, this has been great. I truly appreciate your taking the time with us today. Really good things to think about. Thank you so much.
Thank you very much, Amy. Thank you for having me.